You're listening to The David Knight Show.
Welcome back. We're going to talk about Roe v. Wade because as these laws are passed, as the Alabama governor signed a very restrictive abortion law, it's going to criminalize all abortions by doctors. The doctors will be penalized, not the women, AOC. You're lying about that. Misleading people about that intentionally. Amazing to see how she prevaricates about that. Even when called on it, even when people quote the law to her, she still is prevaricating and lying about that. Yeah, they removed intentionally any exemptions for rape or incest. They said, we're going to go, this is designed to attack Roe v. Wade at the Supreme Court. This is about the issue of personhood. And are we going to say that somebody's not a person because they were conceived on the basis of rape or incest? That's a separate issue, just like these babies are separate from the mother. So they have targeted this for Roe v. Wade. Pat Robertson says, well, I don't really think that that's the case that we want. I think that's going to offend the Supreme Court. Well, don't worry about that, Pat. You don't answer to the Supreme Court, neither do I. We answer to God. And these are overriding principles involved here, and they're overriding constitutional principles. This is really about the 10th Amendment. That's what we're going to get into now in Roe v. Wade. The ACLU, of course, has vowed to sue. USA Today says, what if the Supreme Court overturns Roe v. Wade? What happens then? Well, they said ending Roe v. Wade will not end abortion in America. And, of course, it won't end the fight over abortion. What will happen? Well, as USA Today writes, and they're absolutely right about this, a repeal of Roe v. Wade would shift the battle from the federal courts to the state legislatures, where lawmakers in every state would make their own rules about when, where, and under what circumstances women could obtain abortion. So, for example, in Alabama, none. In Vermont, you could do it for any reason or no reason at all. At any point, all the way up to birth, and probably a little bit beyond that. That's what they just passed in Vermont. And New York is the same way. And if the Democrats control other states like Virginia, that'll be what they're pushing for in those states as well. So it'll be on a state-by-state basis. And they said, well, all federal oversight goes away. That's right. That's the whole point. The federal government has assumed a power that it does not have. There is nothing in the Constitution about marriage, defining marriage. There's nothing in the Constitution that gives the power, the jurisdiction over that to the federal government, the jurisdiction to define marriage, to define life, to define what, how abortion is going to be regulated. That all belongs in the states. And so they said, well, this would result in a patchwork of new laws. See, they don't like this. It's a patchwork. Ooh, that sounds pejorative. Well, no, if they liked it, if the left wanted this, they wouldn't call it a patchwork. They would say it would result in a diversity of approaches to abortion. Oh, diversity, that's a good thing. Patchwork, that's bad. Diversity, good. Or they could say it would result in a multicultural approach. Multiculturalism. Oh, that's good. Oh, no. Patchwork. Say patchwork because that's bad. So you would have some satanic cultures in the Northeast where the Democrats rule, and they would have Christian cultures in other parts of the country, and people could decide where they wanted to live, or they could fight on it, about that issue in the particular states. So let's talk about Roe v. Wade. But before we do, let's take a look at the woman behind Roe v. Wade. Here is Jane Roe. Video clip number 1.
Most of you won't recognize me or my real name. It's Norma McCorvey. I'm also known as Jane Roe, the plaintiff in the Supreme Court case, Roe versus Wade, which legalized abortion in America and changed our nation in an unprecedented way. Back in 1973, I was a very confused 21-year-old with one child and facing an unplanned pregnancy. At the time, I fought to obtain a legal abortion, but the truth be told, I have 3 daughters and have never had an abortion. However, upon knowing God, I realized that my case, which legalized abortion on demand, was the biggest mistake of my life. You see, abortion has eliminated 50 million innocent babies in the U.S. alone since 1973. Abortion scars an untold number of post-abortive mothers, fathers, and families too. You read about me in history books, but now I'm dedicated to spreading the truth about preserving the dignity of all human life, from natural conception to natural death.
Okay, that was Norma McCorvey. And she passed away in 2017, February of 2017. But let's go back to the law. This law was argued in December of 1971, not decided until January of 1973. Took them 13 months to decide this. And here's some excerpts from the actual Supreme Court decision. A pregnant single woman, as they roll out the circumstances of the case, a pregnant single woman, Roe, they anonymized her, this is Norma McCorvey, brought a class action challenging the constitutionality of the Texas criminal abortion laws, which proscribe procuring or attempting an abortion except on medical advice for the purpose of saving the mother's life. Now, see, this is exactly why the people in Alabama didn't have any exemptions in there. They wanted to have a law that was exactly like the one that was decided in Roe v. Wade. They said a licensed physician who had 2 state abortion prosecutions pending against him was permitted to intervene. Now, that is a lie. And I'll tell you why that was. She didn't actually have an abortion. She never had that physician did not intervene. They lied. The very first sentence has a factual lie in it from the Supreme Court. Now, they go on to say, as they lay out some of the facts of the case, they said state criminal abortion laws, like those involved here, that accept from criminality only a life-saving procedure on the mother's behalf without regard to the state of the pregnancy and other interests involved, violate the due process clause of the 14th Amendment. See, this is the basis of this decision that has resulted in tens of millions of babies being killed in America over the last 46 years. And the basis of it was that the only exception was to save the life of the mother, and that's why they did that in Alabama. That's why. That's why, Pat Robertson. We're not going to compromise on life. The state, they said, has a legitimate interest in protecting both the pregnant woman's health and the potentiality of human life. And let me just say this about the due process clause of the 14th Amendment. It's amazing to me that the 14th Amendment is so misquoted and so misused in so many different cases by the Supreme Court. It's not just here in Roe v. Wade. Understand the 14th Amendment, again, was to clarify the fact that the newly freed, formerly black slaves in America after the Civil War were fully citizens and had full access to all due process. That was the point of the 14th Amendment. And they have read all kinds of things like the anchor baby stuff into this, when it made it very clear that only children born to those people who were subject to the jurisdiction of the United States, only those children were born as American citizens. Don't tell me that people who come here illegally, jumping the border, are subject to the jurisdiction of the United States. But then they also used it in this case, in Roe v. Wade. The same institution that had given us things like the Dred Scott decision that would legalize slavery, used the 14th Amendment to target blacks for genocide. Because as you look at this, the language of this, it came directly out of Planned Parenthood. Directly out. And that was their intention, black genocide. She stated it. Margaret Sanger stated that. They go on to say, and I would agree with this, our opinions, you have opinions that are natural and familiar. You sometimes have opinions that are novel or even shocking. They ought not to conclude our judgment on the question of whether statutes embodying them conflict with the Constitution of the United States. That's right. So in other words, forget about what your opinions are about a particular issue. We're deciding about the Constitution. Are they really? That's really the case. And when we come back, I'm going to show you what they based their decision on, because they really didn't base it on the 14th Amendment. It's absolutely amazing to see the sources of material that they drew on, not the U.S. Constitution. And that's what we need to come away from this. We need to use this to hammer in the 10th Amendment and to put a nail in the coffin of the Supreme Court usurpation. Welcome back. We're going to take a look at the decision by Justice Harry Blackmun, the Roe v. Wade decision. And again, just for Joy Behar, I just want to explain to you, Joy, you love Roe v. Wade. It was written by a white male. Those horrible people that you want to give vasectomies to, that you hate, that you're so racist and bigoted toward. It was a white male who wrote this. embracing the black genocide of Margaret Sanger and Planned Parenthood, and Prescott Bush, a white male who was appointed by Richard Nixon, that guy who did so much to help our country. He enacted the UN war on drugs. He took us off the gold standard, which is in the Constitution, and instead put us on a petrodollar where we put the Saudis in charge. But he really put China in charge of the economy, he and Henry Kissinger. And then they gave us other things along the side, like wage and price controls, even telling us how fast we could drive on the interstate, 55-mile-an-hour speed limit. That was Richard Nixon. The EPA he created the Department of Energy. And part of his legacy, of course, is Harry Blackmun and the Roe v. Wade decision. And again, as I said before, they say in this decision, as a prelude to it, they said the Constitution is made for people of fundamentally differing views, and the accident of our finding certain opinions natural and familiar, or novel and even shocking, ought not to conclude our judgment upon the question of whether or not statutes embodying them conflict with the Constitution of the United States. So what did they base it on? Well, the first thing that they go to are, where did we get these abortion laws? And they go back to ancient attitudes, to the Hippocratic Oath, to common law, to English statutory law, to the American law, to the position of the American Medical Association. Well, those are all very interesting. And those would all be very relevant if you were writing laws governing abortion in the states where the authority resides, but it doesn't really have anything to do with the Supreme Court. The Supreme Court is there, as he said, to determine what the Constitution says. We've got all these different views about abortion. Then he goes in and talks about all these different views. And then he legislates from the bench. And that's what the Supreme Court has been doing since Marbury versus Madison. And that's one of the most important things to be attacked here. And I don't even think the Republicans understand that. Even good people like Mo Brooks, I don't really think, this is really about the 10th Amendment. So we'll have to see what the Supreme Court says about it. It's like, no, the Supreme Court has ripped up and shredded and burned the 10th Amendment over and over and over again. We need somebody with a backbone at the state legislature to stand up to that, just like they did on medical marijuana, regardless of what you think about medical marijuana. That is the most important outcome of this, the fact that you had states rightfully nullifying an unconstitutional overreach on marijuana, medical marijuana, and recreational marijuana, the entire war on drugs that was put in by the UN, enacted by Richard Nixon, all of that is a federal overreach. They don't have any authority to get into that. They don't have any authority to define marriage. They don't have any authority to define abortion. And he was legislating from the bench. And he's talking about all these other legal precedents and ethical precedents. Again, English law. Who cares? That's not relevant to the Constitution. Neither is common law. Neither are state American laws relevant to what the Constitution has to say. Again, if he was writing the law as a state legislator, those would all be relevant things to consider, perhaps. But they were simply there to decide whether or not the state could write a law. You don't think the people in Texas or Alabama, these other places, took those things into consideration? He talks about ancient attitudes, the first thing. Then he talks about the Hippocratic Oath. And he quotes, he says, "I will give no deadly medicine to anyone if asked, nor suggest any such counsel. And in like manner, I will not give to a woman a pessary to produce abortion, nor will I give a deadly drug to anybody if asked, nor will I make a suggestion to this effect. Similarly, I will not give to a woman an abortive remedy." Kind of like another Greek medical philosopher, Galen. First, do no harm. Well, it'd be great, if we went back to those attitudes, but it really isn't relevant in the Supreme Court decision. But he goes on and on and on about all that. He goes on about common law, English statutory law, American history of law, and the position of the AMA. I don't really care about the position of the AMA either. It's not relevant to the Constitution. And then he goes on to say the Constitution does not explicitly mention any right of privacy. Yeah, he's right about that, but then they go ahead and invent one. And then they talk about some previous abuses of the 14th Amendment or whatever, whether or not you agree with these decisions, talking about relating to marriage. And of course, there was a prohibition in Virginia about interracial marriage, Loving versus Virginia. They said, well, we use the 14th Amendment to get into that relationship. And then child rearing and education, not to support parental rights in child rearing and education. It's kind of interesting. That particular case that they quoted, Prince versus Massachusetts, 1944. Very interesting case because very much like Marsh versus Alabama in 1946, that we've talked about so often here in terms of free speech, a Jehovah's Witness passing out literature in the public space, it was owned by a private corporation that said you can't pass that out in Marsh versus Alabama in 1946. And the Supreme Court said, well, even if the public square is privately owned, you can't stop free speech there. Now, in 1944, very similar case, you had a Jehovah's Witness passing out literature in the public square. But they didn't use the argument to try to stop them that it was privately owned. Instead, as they were passing this out, they had a little can there, like Salvation Army, for voluntary donations. And they said, you're selling this stuff. And furthermore, you have your child there with you passing out literature, 12-year-old child. So we're going to get you on child labor laws. And they went to the Supreme Court, and the Supreme Court said, yeah, based on the 14th Amendment, we can do that. Are you kidding me? This is the kind of mental gymnastics that the Supreme Court goes through. Anyway, they talk about the right of privacy. They said maternity or additional offspring. Listen to this. This is, they don't cite Planned Parenthood, but right here in Roe v. Wade, this is a Planned Parenthood religious tract, if you will. Okay, I just talked about the Jehovah's Witnesses handing out. Well, here's the religious tract that is handed out to every woman who comes into a Planned Parenthood clinic, and it's right here in Roe v. Wade. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by child care. There's also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable psychologically or otherwise to care for it. All of these factors, the woman and her responsible physician necessarily will consider in consultation. Again, that is nothing but Planned Parenthood dogma. That's the little religious tract that they hand all the women. They said a pregnant woman cannot be isolated in her privacy. She carries an embryo, later a fetus. There's always been strong support for the view that life does not begin until live birth. This was the belief of the Stoics. Again, what does that have to do with the Constitution? Totally irrelevant. This thing goes on page after page after page of nonsense. It never gets even to the issue. It isn't the responsibility of the Supreme Court to decide when life begins. That belongs in the states under the 10th Amendment. We'll be right back. Stay with us. Welcome back. We've been talking about the new abortion laws that have been enacted. And again, there was another one that was enacted after the Alabama law was signed by the Alabama governor. Basically, it had no exceptions for anything other than the life of the mother. It would penalize the abortion doctors. And as many people, including Pat Robertson, criticized them for doing that. They said, well, our point is that God is the one who creates life. It's not allowed by the Supreme Court. And they intentionally took out restrictions, or I should say, they took out exceptions for rape and incest because they said we wanted to parallel the statute that was there in Texas at the time. And we're not going to say that life is defined by anything other than by God. Life is not defined whether or not you were conceived based on rape, for example. They wanted to make that the focus. So they were very intentional about that. So I said, well, let's go back and take a look at Roe v. Wade. And when you go back and look at the decision, it is absolutely amazing how they reference, they say, well, you may have natural opinions and you may find some other people's opinions very shocking, but we're here to look at what the Constitution says. And then they don't do that. They go back to Greek medical philosophers. They go back to English common law. They go to American law tradition. They go to what the AMA has to say. And here we are, as they draw their conclusion, they say there's always been strong support for the view that life does not begin until live birth. This was the belief of the Stoics. So what? You're not there to make a decision like Solomon. It doesn't matter what the Stoics thought. It's what the Constitution says. The laws are supposed to be written under the 10th Amendment. These laws should be written at the state level. They also say it appears to be predominant thought, although not the unanimous attitude, of the Jewish faith. Again, even if that's true, so what? So what? What the Jewish faith believes about when life begins, what ancient Greek philosophers believe, what foreign laws say, have no bearing on whether or not abortion laws in the United States are constitutional or not. And the 10th Amendment says you don't have the power. They said physicians and their scientific colleagues have regarded that event with less interest and have tended to focus on either conception upon live birth or upon the interim point at which the fetus becomes quote unquote viable. Well, all those scientific opinions might have changed in the last 46 years after they look at 4D ultrasound. But here's how they summarize it. They say to summarize and to repeat. They say for the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. Where's that in the Constitution? See, this is based on, again, on all the philosophy and the foreign law and the opinions of this religion or that religion. That isn't anything about the Constitution. All of that would be relevant discussion at the state legislatures, but not for the Supreme Court. That is not for them to decide. They go on to say, for the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health. Again, all this arbitrary law writing that is not, people say, well, Roe v. Wade is the law of the land. Well, the Supreme Court doesn't write laws. Congress is supposed to write laws. And they're only supposed to write laws about things that they were directly given responsibility for. The 9th and 10th Amendment said, even if we don't expressly prohibit you from writing laws controlling our ownership of guns or taking away our free speech and so forth, even if we don't expressly prohibit you from doing that, you don't have that unless we expressly give it to you. It's still retained by the people and by the state governments. But they don't care about the Constitution. The state, they said, may define the term physician, as has been employed in preceding paragraphs of Part 11 of this opinion, to mean only a physician currently licensed by the state, and may proscribe any abortion of a person who is not a physician as so defined. Again, arbitrary law writing by the Supreme Court. Our conclusion that Article 1196, that's a Texas law, is unconstitutional means, of course, that the Texas abortion statutes as a unit must fall. Who cares? Who cares what these people say? Absolutely blatant abuse and usurpation of power, totally irrelevant to their task that they stated at the beginning. They say, we're going to take a look at what the Constitution says, and they don't do that at all. They don't do it at all. As a matter of fact, they try to invent the right of privacy out of this much beleaguered, benighted 14th Amendment. It seems to be the catch-all for every kinds of intervention that these people have.
It's the David Knight Show.
Infowars.com/show. We're bringing back one of the biggest fan-favorite formulas we've ever offered with even better ingredients. Ultimate Bone Broth. InfoWars Life is proud to bring you a powerhouse bone broth formula to help push you to your limits. This incredible formula will help you get the most out of your workout with the power of ultra high-quality bone broth, one of the most popular health trends on the planet. Built with more than 7 different superfoods and crucial compounds, Ultimate Bone Broth will help support your healthy muscles, digestion, tendons, and ligaments, while also supporting your body's fight against free radicals. This incredible chicken bone broth formula contains time-tested ingredients such as turmeric root, chaga mushroom, goji berry powder, bee pollen, and alfalfa herb powder to support your body. It's time to experience what Ultimate Bone Broth can do for you. Get Ultimate Bone Broth now at 50% off.